objection, leave is granted. Senator Ludlam.
Deputy President, I seek leave to take note of the government response to the 126th report of the Treaties Committee.
Is leave granted? There being no objection, leave is granted. Senator Ludlam.
Thanks, Mr Acting Deputy President. I'll just make some brief remarks about the government's response to the 126th report of J. Scott, which senators might be forgiven for not knowing, was focused on the ACTA treaty, the Anti-Counterfeiting Trade Agreement. It's one that has been widely discredited, so this report by the Australian government into the treaties discussion of ACTA is greatly appreciated. This has been described as an extremely lonely bandwagon that the Australian government's piled onto a bandwagon that nobody else is on. So I've actually been waiting with some interest to see what the government would make of the Treaties Committee's highly critical report into ACTA. Generally, Treaties Committee, which is one that I've really enjoyed serving on for the past 4.5 years, is pretty diligent in its work, but it's rare to see language as strongly as this deployed in effective condemnation. And this was a unanimous report into ACTA. Now, the first European Parliament's rapporteur, Kader Arif, resigned in protest when the EU signed ACTA. The European Parliament's chief investigator into ACTA recommended against it, and then the European Parliament voted against it. So J. Scott produced a very strongly worded document with a large number of conditions attached to the treaty being ratified by the Australian government. Effectively, it was a red light. It said, do not ratify this thing until you have satisfied these various conditions and until you're in possession of some very specific kinds of information which haven't been provided. Yesterday, we got a really weak response. The Treaties Committee found and exposed very deep flaws in the national interest analysis and exposed a failure to assess the costs and benefits. We were told it's fine. The national interest analysis already includes a requirement for a regulatory impact statement. What the government response reveals to me is that the government has barely even read the Treaties Committee report, and that it's, while on a first brush it looks as though the Australian government has agreed with a great deal of what the Treaties Committee found, when you go into some of the summary text and some of the exposition as to what the government thinks it's agreeing with, it's fairly apparent that the treaties report wasn't read, or if it was read, it certainly wasn't understood. The response, for example, reveals that the government is still not considering the issues raised in the inquiry about the costs. So trade treaties such as this are sold to the Australian public, into particular industry sectors, as being all benefit and no costs, and we wanted a proper cost-benefit analysis conducted. There are administrative costs of participating, for example, in yet another forum on IP and coordinating that with all the others, including, here's an acronym sandwich, WIPO, the TRIPS Council, the WCU, the WHO, and our trade agreements such as the AUS-FTA, the Unloved Free Trade Agreement. And I remind senators of what the Productivity Commission said about these bureaucratic costs. There are real costs of locking us into a given model in an area that is changing as rapidly as IP. The government have indicated that they are getting some independent analysis, and on that there's one sound instance where they have listened to the recommendations of the Treaties Committee. I commend the government for that, and I thank the Minister's Office for responding very rapidly to our calls yesterday to find out who's doing the analysis and when it's likely to be produced. And I do thank the Minister for providing us with the information. It's PwC that they've been working on this for at least 2 months. They will table sometime towards the end of the year, says the government's response. I hope that's not on Christmas Eve, along with all the other stuff that tends to get tipped into the public domain while nobody's watching. This one, I think, is going to be particularly interesting. I remind PwC and the government that if the review was truly independent, we would actually expect them and hope that they get in touch with stakeholders and experts, starting, for example, with the people who provided evidence to the Treaties Committee. So I look forward to seeing who PwC actually did consult with, find out who they spoke to and what kind of modelling they've done, and what their inputs were in particular when assessing the cost of these agreements. It won't be good enough if they just wave their hands, as the government seems to have done, and said there are never any costs to these kind of things. In the absence of some calculation of the cost of the present system, let alone its benefits, there's no real basis for asserting that the system that we have at the moment strikes an appropriate balance of interests, or that it should be internationalised. The government has provided some very brief clarifications to some quite complex problems. And its response to recommendation 4 is fine, but it doesn't explain why the trade-related aspects of intellectual property rights provisions aren't in ACTA. The clarification of the term aiding and abetting in recommendation 5 is not helpful. These are clarifications that don't actually clarify. We need examples of the kinds of thing that they envisage would be included. So reference to intention is useful, but how do we know whether the intention is an intention to do the act that aids, abets, or an intention to participate in IP infringement? These are serious grey areas that the Treaties Committee in good faith asked the government to clarify, and in the course of clarification the government unfortunately has done no such thing. The government responds to recommendation 6 that asks for a clarification about what actually constitutes commercial scale by quoting the treaty back at us. Well, we already have the treaty language. I don't understand how our laws can cover indirect commercial advantage, for example. It's still entirely unclear. Section 132AC talks about substantial prejudicial impact and commercial scale, and the latter it remains undefined. Section 132AD talks about profit or commercial advantage without any further definition or clarification. As we know, Article 23(1) of ACTA provides a very broad definition of commercial scale, including at least those carried out as commercial activities for direct or indirect commercial or economic advantage. This definition applies to single acts, and hence operates effectively to remove any requirement of commercial scale in determining that an act is criminal. Under the ACTA definition, for example, forwarding a single email without permission of the copyright owner, i.e. the author of the email, in a business context could therefore be construed as being a criminal act. And that is the sort of grey area that we're talking about here. It's hard to imagine many businesses that don't engage, inadvertently, in some criminal copyright infringement on this kind of standard, given the broad prevalence of copying of newspaper articles, journal articles, and pictures to put in PowerPoint presentations or brochures or whatnot. If that is to be construed as commercial scale, and on a strict reading, it could be. We would appreciate clarification from DFAT as to how the definition of commercial scale under ACTA is in line with existing law, given a number of academic submissions to this inquiry disputed that. References to provisions, subsections, explanatory memorandums, anything at all specific will really be helpful. Overall, this response reads as though the government haven't changed their views at all. They've simply disregarded the findings of the J. Scott inquiry and are assuming that these issues can be sorted out with the kind of glib and rather dismissive response that we have here. I'm alarmed because we've been here before. In 2004, a Senate inquiry found that IP standards adopted under the Australia-US Free Trade Agreement were at a net cost to Australia. We are a net IP importer, not exporter. And the standards that we adopted actually cost Australia. The Senate inquiry, needless to say, strongly condemned the process of negotiations whereby we just handed these advantages and these issues off. In 2010, Australia concludes ACTA, reinforcing the same problematic standards that we had an issue with in 2006, and negotiating it in much of the same way, marred by allegations of secrecy and lack of protection of the public interest. In 2012, another parliamentary committee has found issue with ACTA, just as with the Free Trade Agreement in 2006. And yet again, DFAT has not bothered to address whether our negotiating stance is actually appropriate. Here we are again in 2012, with Australia negotiating yet another trade agreement with an IP chapter, the Trans-Pacific Partnership Agreement. And again, DFAT's negotiating position is to encourage the adoption of standards, in inverted commas, consistent with Australia's own. We know that the ACTA text is on the table. We know too previous parliamentary committees and a host of academics, economists and NGOs have issues with those standards. So what independent economic analysis determined that these standards were appropriate? And will the next parliamentary committee find the same issues in the TPP as they have in the Free Trade Agreement and ACTA? And at what point will DFAT actually start listening? There's no real evidence presented in the government's response to the treaties report that the government is listening just yet.